Good afternoon, everybody. This is episode 16 of Call to the Bar, and I am joined kindly by Paul Abrahams, who is a barrister at Park Square Barristers. I always get confused and feel like saying Park Square Chambers, and then I realise it's Park Square Barristers. He is also the deputy head of Chambers and the head of the Teesside office as well. Paul was ranked in the Legal 500 and also was awarded Chambers and Partners 2026, called in 2022 and sorry 2002 not 2022, and is a grade 4 prosecutor, and also an approved rate prosecutor. So today I'm going to be talking to Paul and asking him for tips on preparation in jury trials, and also how to deal with vulnerable witnesses and young witnesses. A lot of Paul's cases involve serious sexual offences, rape, and also some multi-handed defendant trials as well. So I'm going to be asking and quizzing Paul on all of those. I'm incredibly grateful to you, Paul, for joining me this afternoon. Thank you so much. And I know you're very busy, so it really means a lot to me. And
That's
if I've
fine. No
introduced you
problem.
correctly, then
Yeah, that's absolutely fine.
yeah, I shall start. So you, firstly, in terms of preparation, you receive your instructions, and what do you first do if it's a really heavy case brief? What is the first thing that you like to do?
I'll start by saying preparation obviously depends on what stage in your career you're at, because when you're early in your career, things are very much thrown at you at a very late stage. So it could be the night before, when obviously you get more sort of senior in terms of the work that you deal with. The work that you do often comes in generally in quite advance of the hearing. And so you've got to be a lot more adaptable when you're more junior to deal with sort of the prep, because it is very front loaded. And so, in terms of how I deal with work now, so well, back then it would be literally just firefighting. It's just sort of get as much information as you can, and you will adapt as to really knowing how to fill it a brief, sort of actually pull the skeleton out of it. Because it's certainly when you're prosecuting at sort of magistrates level, there's a lot of material that is just irrelevant. It's sort of padding material. It's sort of repeated advices. So it's learning that skill to draw out the key documents as such. Same applies to a degree when you get more senior, because obviously we have this new system. I say new, it's probably about 10 years old now, but um, the digital case system where everything's sort of uploaded onto a portal where you can access it. And so there is less of the sort of irrelevant material thrown in, and it's more directed as to where the exhibits are and witness statements are. But again, sometimes, particularly in large cases, what you'll find is that CPS will upload duplicates of documents, or they'll upload them into the wrong sections. So it's just been available to sort of check that. But in terms of how I would approach a case now, the first thing I would tend to do, if I'm prosecuting or defending to a degree, is find out, certainly with defending, find out and speak to my solicitor, find out a little bit more about the client, because there's no straight jacket way of dealing with a particular client. Every client deals with things differently, and your instructing solicitor, on the whole, will have dealt with that client a number of times before your case. They'll have probably been through the magistrates quite a number of times. From being young, they'll have got a good relationship with the solicitor. And what you can't do is try and have a one size fits all approach where you go in there. And I think that's sort of the approach that you probably have at bar school, where you think, I've got an idea what I want to do, this is how I'm going to do it, and you're going to just effectively follow what I'm going to do because I've learned this way to deal with it. Problem is that sometimes immediate contact with the defendant, who might not like that approach, you've just got to be very sort of hands off, and find out how this person is going to react to what the issues are. And your solicitor might have an idea as to whether or not this person is amenable to discussion about the evidence. I'd say we can all sort of read a case and think, well, it looks fairly overwhelming. But if you go straight in saying this is really overwhelming, you're going to lose your confidence, and you're going to lose your brief effectively, and you might upset your solicitor, your professional client, as well as your lay client. And so it's very much a sort of a softly approach with sometimes with some defendants. And so the key thing to do is find out a little bit more about the case and the defendant from your solicitor. So that's the first thing I would do in preparing that. CPS, it's not as important because obviously you're prosecuting the case, but it's often helpful to speak to the reviewing lawyer, find out who the reviewing lawyer is. It's often available to be found on the digital case system, and speak to the reviewing lawyer to find out heads up about, what the bottom line is for the Crown Prosecution Service. Is this a case that's liable that could be dealt with by alternatives? I mean, what's the complainant's position like in respect to this? So these are things that often aren't necessarily written down in a formal brief as such, and so it's important really to touch base with your instructing solicitor, defence or prosecution. Then it will give you an idea how to then approach how to prepare the case. And so the first thing is touch base. Now you can't really do that necessarily as a junior barrister because you're going to get it the day before. Defending, you could possibly ring them up, before you sit down at night to read it, have a chat with the solicitor. CPS less so. CPS it's very tricky when you're dealing with sessions because there's a lot of material, and it would be very difficult to probably get in touch with the reviewing lawyer on a case. But that would be my sort of approach is to speak to your professional client first of all to get an idea about where this case is going, so you've got some semblance of an idea as to which direction it might be going.
Amazing, thank you so much. And also, how important would you say it is to have a conference with your lay client where it's appropriate? So I appreciate some lay clients may not want to speak or maybe a bit difficult or angry, but
Yeah,
what,
a few aren't. Sometimes you get them where particularly if they're in custody and they don't want to be in custody, or you've got someone who's not in custody, they're on bail and they just don't have the means or the ability to get about. That's sometimes a little bit better these days with telephone conferencing and things like that. But it's always important if you're defending and you get the opportunity and you've not got the brief just the night before to have a conference beforehand, to have that conversation with them, to feel them out, get an idea of who they are as a person, what their expectations are likely to be, how are they going to be able to understand, first of all, obviously, if there's any difficulties with communication or understanding, but to really, get a feel of where you are with the case before. And it's not, this is even before you've necessarily even really got into the detail of the case. It's just to have a feel as to where this conversation could go. Obviously, you read it before you then have your conference, but um, you really do need to have an understanding about your client, lay and professional, about what their understanding is and how they're going to approach it. So you can modify. Adaptability is the key. And that adaptability you learn and start to learn dealing with the magistrate sessions because you just do not have the time to prepare every single trial you'll have in the magistrates, or if you're dealing with the sort of the lists, you'll get a list of cases. You don't have the time to do that. So you've got to learn that ability to be able to sift out, pick the bones out of something. I think this is where I'm going. This is where I want to go with this case, and have that flexibility of approach. And it just comes with experience.
you just actually took over the answer for my next question, which was literally going to be when you talk about the skills that flourish in throughout practice, do you think a lot of them do start to develop and get better, especially in the magistrates when you're doing the sessions as well? I think you've just said when you learn to pick out things because as a bar student, I sometimes sit and think, how on earth do you work through volumes of material? But you've just said that you start to pull together a skeleton argument
Yeah,
before.
I some chambers don't like pupils to do a great lot of work in magistrates in sessions, so particularly we're doing sort of bulk work in the magistrates court. And they'll want to sort of be doing mentions and PTPHs in the Crown Court, but you're not going to learn your base skills doing that, nor are you going to build your contacts. The way to really sort of hone yourself and knock the edges off is to go into the magistrate, and it is hard work. When I started back in the sort of early 2000s, there wasn't as much work for junior barristers in the Crown Court. And so I spent a lot more time in the magistrates courts dealing with trials, as did my sort of contemporaries at the time. We would be in the magistrates for now, 3, 4 years, dealing with sessions, etc. Whereas with sort of junior barristers now, they're finding themselves thrust into the Crown Court very early on. And so there is that opportunity to get to the Crown Court early. But sometimes by doing that, once you're in the Crown Court and you've started to make mistakes, your card is already getting marked by the judges. So it can you might want to be there in the Crown Court dealing with the Crown Court cases, but don't overlook the Magistrates Court because it's important that you do that work. It is hard work. It is a real grind. Um, but you will learn a great deal doing that,
Yeah.
and it will make you a more complete barrister because, as I say, you're learning the trial skills, you're learning that skill to assimilate information in a quick way, in an efficient way, and you're making the contacts. You're making contacts with reviewing lawyers from CPS. You'll see them there. You won't see CPS reviewing lawyers much at the Crown Court. It will be caseworkers, and you will see solicitors more in the Magistrates Court than you would in the Crown Court. It's quite rare that you would get sort of senior partners necessarily appearing on a regular basis, unless they've got higher rights, of course. But at the Crown Court, you will though see them at the Magistrates Court, and that's where you're going to cut your teeth dealing with criminal work. And it's cross transferable as well with sort of family practitioners, not so much necessarily civil. It's a different sort of obviously style of advocacy in that sense, but you're going to learn your basic skills of cross-examination, and you're not going to be tarnished if you make a complete fool of yourself. Because there's that bench that you dealt with at whatever magistrates court on a Thursday in December is not going to remember you. Whereas if you're in a Crown Court on a regular basis, the judges will remember you.
Yeah, and I think you just explained there what cutting your teeth means. I've heard that so many times, and I used to think, what does cutting your teeth mean? But you've just explained that, so thank you so much.
Well, I think that's the sort of the way to explain it in terms of in practice. How that phrase came about, I don't know. I'm sure I can Google it and find out what it means. But
Yeah, I think thank you so much. That's made a lot more sense to me. My next question is: we often get told as law students and especially bar students as well, read the case papers once, twice, three times. I know that people have different skill sets. Obviously, in real life, some people might not have to read it three times. But do you think that you have to read it every single line three times or
no,
four times? Thank
no, you'll not. For starters, you'll not get the chance.
you. Yeah.
You're never going to get a chance to do that with dealing with magistrate sessions. It's just not going to happen.
Mhm.
Um, Try and get through it once at least, and then, as I say, you'll learn to be able to start picking the bones out of things. Um, Crown Court is different. You're not going to read it three or four times in one go first as you get the brief. You've got to sort of build in because with the listing as it is, even if this and when they are starting in some court centres to bring in more courts to deal with more cases sooner rather than later because of the backlog, you're still talking about a huge sort of gap between when your trial's in for PTPH. Sometimes then you've got Section 28, and then there's still a 2 year gap after that. So you need to build in periods about when you're going to prep it. So I would obviously encourage you read the details thoroughly on the first occasion when you get your brief. So you've bottomed it, you've known an idea, and you'll make some case prep notes about the case that you'll then be able to discuss in conference with your client and at the PTPH. So you're fully prepared at that stage. What I then tend to do is what I try and build in then is because of this huge lag in sort of timings and prep, is that you run the risk because what will happen is CPS and police will sometimes just upload information, evidence on the system, with very limited warning about that. And so if you've not built in a system, there could be some scientific report that appears on the system about 8 weeks before the trial when the trial was listed 2 years before. And if you've not built in a system to check that, you might miss that. And then you turn up at trial and think, well, I can't accept that report. And the trial goes off and the judge will say, well, why haven't you done that? So you've got to build in a system. And the system, I suppose, again, it's flexible. It depends on how you work, how you operate. But the system I tend to use is read my papers, obviously detailed on the first occasion in advance of a conference and the PTPH. There are then two natural points then where you can build in what I like to do is sort of a full detailed trial prep, and that is when you're prosecuting. Once the evidence is served, it's called stage one date. So you have like a four-stage process. Stage one is service of the evidence. Stage two is defence statement. Stage three is the review of the defence statement and disclosure review by CPS, and stage four is when you would do any Section 8 applications for disclosure, if there is any. What I tend to do is that with CPS, after stage one date, they require you to do what we call a bar standard advice, bar standard two advice. And that is that they seek to say, look, 14 days after stage one, you need to do a full case review. Now that sometimes, I suppose, in the past, sort of 20 years ago, it used to be almost sort of back of a bar mat sort of advice saying, "Oh, it's there, check, it's there, it's there, it's there." Because cases have become more bloated these days with complex evidence, because principally because of mobile phones and technology, etc. There's a great deal more material you've got to get through and make sure you've checked off, and also with social service records and things if it applies in that case. So what I tend to do is do a full detailed review, including unused material, which you might not necessarily gone through in as full detail because you won't have got your client's account, so you won't really necessarily know what the defendant's account is because that will be sort of given to you at the PTPH. But once you're given that sort of heads up about where the likely issues are to be, you can then have a more detailed review. And what I tend to do is draft a full case opening at the bar standard stage. So at that point, I have got my opening, and it may be that my trial's not for 2 years' time, but at any point that case comes in, I can just read my opening. And then what I know is then, because I'll have checked off, I can look on the system to see if there's anything new. And so once you've done that, if it pleads, you've got the basis of a sentencing note, you've got or if it's a trial, you've got the basis of a trial. And that's done at that stage. And then I'll also then have a further date, usually about 2 months beforehand, just to check to make sure there's nothing beforehand. So I'd like build it into my diary to just to check. Defense, it's slightly different, obviously, because you're not sort of building a case, you're trying to bring a case down in a sense. What you would tend to do is I prep it for trial effectively at the defense statement stage because I'll have had a conference with the defendant. I'll have a good understanding of what the likely issues are, what sort of my case strategy is at that stage. What are the areas I need to focus on? And so it's effectively, I'll have gone through the evidence, I'll have identified what the disclosure points are and set that in my defense statement, and then also then build in at a later point a sort of a review date. But that's the beauty of sort of being instructed at the more senior level because you've got that time to do that. When you're dealing with magistrates level as a junior barrister, you're just not going to get the time. You're going to get your papers maybe 1 to 2 days beforehand, and you might be dealing with 5 trials to prep. So that's certainly what the pupils have been dealing with in recent times. So it's very much of a horses for courses sort of
Yeah, of
way.
course. It sounds like a lot of organization skills as well, really, just like working
Yeah,
out your.
you in the past it wasn't as such, it was very much advocacy is what it's all about. There wasn't the sort of the case prep because cases at the end of the day back then involved generally an eyewitness or a complainant, and you could utilize the skills you've had for years going through setting out in detail what your case is and just putting it to the witnesses. It's changed. The whole system's changed, usually because of the pure volume that there is now to deal with in terms of material. And smart mobile phones have just completely changed how, and we will get back if I know you've got a question later about murders and what's the thing about murder cases, but the smartphones have radically changed the way that sort of certainly complex cases are dealt with. There's that much material to go through. So you've got to be organized to deal with it.
I'm sure you heard about the murder in Luton, the Nicholas Prosper who shot his
Mm.
mother and sister and brother. And I watched the episode of that on 24 Hours in Police Custody. And
I
they,
did as well.
yeah, it was brilliant, wasn't it? And part one and part two.
Interesting. Yeah.
Yeah, I mean, not brilliant. That's a little bit of a stretch. It's a pretty sad case, but it was an interesting episode, is what I was supposed to say there. And I watched the experts in the technology within the CPS go through all of the phone
Yeah.
history searches, and it was incredible how much they could go back and how many searches and how much material they had to work through. So yeah, I think that technology is having a massive weight on things now, isn't it?
Yeah, it's good in the sense that certainly, as I said, we'll come to with the murder cases. It means that there are a lot more secondary parties that are getting brought in with the prosecution
Hmm.
because of what would have been a chat on a phone that would never be recorded on an analog telephone is now there to be seen, but it's bringing all that material together. You've not only have you got the messages, you've got sort of, there's multiple different types of different, obviously, messages with social media and SMSs and MMSs, etc.
Mhm.
But you've also got sort of data, sort of where people are, etc. So there's a sort of whole raft of material that you've got to be prepared, and you've got to be organised. It's just that much to do. They're a lot more bloated.
Absolutely. So in terms of jury trials a little bit more specifically then, what would you say the most difficult part of a jury trial is? It maybe the preparation, it may be actually in proceedings, just whatever your answer to that would be.
It depends on the case. If you're defending a case where you've got you might not have a great deal to put in terms of the defense. It might be a fairly overwhelming case, and therefore the cross-examination or the actual issues in the case may be straightforward. But then again, your closing speech might be terrible. Must be, because you've got to actually think of something to say. And so therefore, in a case like that, it can be often be your closing speech. Similarly, with a prosecution, it could be sometimes it's the closing speech if it's not the strongest of prosecutions. Whereas in some cases, it may very well be the closing speech is really easy, because there's a lot of material to go through. So it really depends specifically on the case. It's very subjective as to what's the easiest bit in a trial or not. Um, a difficult task that people struggle to sometimes actually master, which you'd think on the face of it's easiest, is actually dealing with evidence in chief.
I was just about to ask you that question because on Thursday I had my first ever session, and I came back thinking I'm just going to relocate to Japan and sell my passport because it was absolutely horrendous. And I remember
Yeah,
thinking, I don't know
you,
how you
you,
guys do it.
well, again, it's entirely case specific. You've got to try and get to the point. What I tend to do, because what you don't want to do is just go in at the deep end and say something that you're going to later regret. And I suppose it's very difficult to sort of stage manage in terms of a mock trial. What I would tend to do is have an idea with whoever is defending. So if I'm prosecuting and I'm going to elicit some information, I would generally, not necessarily in every case, but in a complex case, what I'll tend to do is the day before, I've done a multi-hander case recently, where the day before, each day, I'd send a batting order out to the defence with a number of the statements where I've crossed through where it's inadmissible, and I've sort of highlighted where I think I can lead, because you want to get to the point. A lot of people don't start, they start off open with the open-ended questions right from the outset, and what'll happen is you'll lose control of your witness, and your witness will just go off in on a tangent. What you need to do is get to the point and sort of say, well, look, speak to your opponent, find out what's in issue. Do you take issue with date, time, etc.? And just effectively ease with leading questions up to the point where there is an issue, and then start with your opening questions. You can lead, obviously, in evidence in chief, and often, particularly sometimes if there's an area of the evidence that's inadmissible, sometimes you might want to sort of discuss with your opponent or the judge a form of words to get around that sort of lump in the road. Because if you go with open questions, you've got to keep control of your witness. So be quite strident, you know, work out where is the point in issue, and establish with parties where that is, and then you'll retain control of your witness.
Okay, so just working out the agreed facts almost to then you know how you can
Yeah,
use.
you've got to work out what the issue is. So if it's identification, there may not be an issue about really much what happened in terms of the incident. So you want to not necessarily lead throughout, because sometimes it loses the impact with the jury, but you want to establish what are the areas of real contention. Discuss it with your opponent. Say, do you have any objection me to leading up to this point? Because you don't want to just start doing it and then you're getting sort of barracked from the side saying, what on earth are you doing? Why haven't you told me about this? And if there's any point of contention between parties, so if you say, well, if there's ever an issue, just run it by the judge. Don't just dive in and do something. If you think that, or you're slightly concerned about something, about whether it's admissible or not, just run it by the judge. It's far easier to iron it out before it happens, And so before you've sort of unleashed it on a jury, because it's very hard for a jury to be erased from a jury's mind if you put it out there and you shouldn't have.
Absolutely. And out of all of the things in a trial, what do you enjoy the most? And I know it'll be case specific on
Yeah,
case.
it's case specific. I like it sometimes with when you've got a good bit of cross-ex where you know you've got the sort of some good points where you can land them and you can sort of work the witness into a position where you sort of you really are backing them into a corner and they don't know that you are.
Yeah.
So an example might be, for example, if you've got someone who is clearly exaggerating, go with it.
Mm.
So let them exaggerate because they'll think, well, hang on, because they'll be ready if you're cross-examining and you're there, and they're going to expect what everybody expects, the sort of the a few good men approach of shouting and bawling at each other in court. That's not obviously how it happens, but that's what they're going to expect because that's what they'll have seen on television. And so if you sort of start off as nice cop and start sort of giving them answers what fits with their case in their head, then that when it comes to it, when you then drop the bombshell, you save that right to the end. You've made your point. And it's a great feeling to see that building up and we're all going to plan in that sense. Likewise, a good when you know you've got a good speech and you've got some good points,
Yeah,
they're,
absolutely.
they're the good bits. So it's when you know you've got something that you've really got some good angles, some good points to make.
Must be quite difficult to tone your facial expressions down when you know you've just landed quite a good point as well.
Yeah, I
Not
don't always.
yours, not
No,
yours
I don't always successfully
specifically.
do
Not
it.
yours specifically, I just mean in general.
A friend of mine, Gary Wood, always reminds me of once in a multi-handed case we did. I turned around and said to him, not as probably as quite as I intended when I went nailed it. Sat down
Quite
initially.
loud as well.
I didn't intend it to be that, but it did. So, but yeah, there are moments like that, and obviously it's difficult to do the poker face in that sense.
Yeah, well deserved though. Does anything make you anxious when it comes to jury trials or not?
Um, Not really now.
Mhm.
I do pretty much one a week almost. If I'm not doing a long trial, this takes 4 weeks. I've done that many. It's difficult to. I mean, there's the odd moment where you're thinking, "Oh God, what am I going to say in this speech? I've got absolutely bugger all to say," sort of thing.
Mhm.
No one likes that when you know that the jury just going to be looking at you thinking, "What on earth are you talking about?" So they're not always the easiest sort of moments. I wouldn't say it was necessarily anxiety. It was more just like please, can we just roll on 90 minutes or, well, no, I don't really do speeches for 90 minutes unless it's a big case, but, roll on 45 minutes time because I just want to get out of here as soon as possible sort of thing. So there's those moments.
Right.
But
Not really
not
anxious.
generally. Yeah,
Yeah.
normally you're that prepped and that ready and you're that sort of exposed to it. Obviously, when you're younger, it's not. You're going to be nervous because you're going to be dealing with trials on a regular basis, and you've not got that background of experience. And in some respects, if you've got a sort of a practice where it is significant violence or some fraud or significant sexual allegations, you tend to start to gravitate towards similar sort of cases. So you become more familiar. It's like silks. Obviously, a lot of silks just effectively do murder. So they'll know sort of joint enterprise and the fine elements of Joji inside out sort of thing. But they won't have necessarily be doing drafting sexual indictments. So whereas when you're a junior barrister, you're in the magistrates, you're dealing with a whole raft of different cases, and you might be dealing with things where you've got prosecuted by the local authority under building regs. You've got driving offences, you've got all manner of matters that, in actual fact, you're probably dealing with stuff that most senior barristers won't have a clue about by the
Mhm.
time, because by the time that they've got to their stage, they won't know what was happened legislation wise or case law wise on those matters.
Yeah.
So yeah, it can be quite easier to prep and and feel more comfortable when you're more experienced because you're dealing with stuff that you're
Different.
more and you're in a sense more able to manage your diary and work out what sort of cases you want to be doing.
Yeah. And what type of cases would you like to continue doing for definite?
Um, I
If,
quite like what I do at present. I do like, I have to say, I do quite like dealing with sort of complex sort of conspiracies and things and putting them together.
Mhm.
The sort of the sort of standard, obviously that's from a legal point of view, standard sexual allegation cases. They once you've dealt with so many, there are only so many sort of defenses or issues that arise, and factually that they're different, but in terms of the law, relatively similar. But I quite like dealing with sort of multi-hand cases and putting them together. Certainly, I've enjoyed a couple recently prosecuting a number of sort of multi-handed cases. One, a sexual one that's currently ongoing. Um, we've gone part one's been done, part two's coming. It's just it's quite nice. It's quite satisfying to sort of build it up and cut through it and get to the issues and present it. That I quite like.
Yeah.
So
And watch
yeah,
the progress kind of as well.
yeah,
Yeah.
yeah.
Definitely. Thank you very much. So, you've kind of my next question was going to be what you would have advised pupils and junior barristers to do in terms of preparation, but you've kind of covered that to read the papers, especially when you're in the magistrates, you're not going to have time to go through it with a
Yeah,
fine.
read them as best you can.
Mhm.
Um, and try and, as I say, try and work out what are the key bits you need to look at and review.
Yeah. And in terms of keeping that good connection and relationship with an instructing solicitor, what would you say for them to call them after the hearings and keep them up to date? Have like, politeness, courtesy, things like.
Yep. Always be in touch. Always make sure you've touched base beforehand. You've discussed the case with them beforehand, so you're able to iron out any potential issues. Because it may be that you've looked at the papers and you take a different view to your solicitor as to how the case should or ought to progress, and therefore, what they might not appreciate is if you turn up having not discussed it with them, giving contrary advice to your lay client that's sort of undercutting your solicitor. At least if you've spoke to them beforehand, you can um, at least explain the situation, and it may be that you've looked at it incorrectly. So and then you've unnecessarily upset the sort of apple cart in terms of your instructing solicitor. So just be open to communication, and make sure you always complete attendance notes within 12, 24 hours, because what will happen is if you've done a case, invariably, because you don't see it at the bar, but there'll be the solicitors will be getting bombarded by calls from family members or the defendants, sometimes almost immediately after a hearing. And it can be very embarrassing to them if they're then left thinking, well, we don't know what's happened at this hearing. We can't give you this information. And the longer that goes on, the worse it gets, because it doesn't look professional from them. And then they're sort of questioning, well, why have we instructed this barrister to deal with this when he's not telling us or she's not telling us what's happened? So, what I would always say is try and get your attendance note off ASAP, just because your solicitor then is able to field those telephone calls, etc., from family members.
Yeah. Thank you for that as well, because I think that's sometimes I know I did a little talk on Friday with my old university just to speak about like the bar course and what it's like so far. And I think a lot of them don't even realise that you have instructing solicitors. Like so many people at, undergrad level you don't get told that at university. So I think
Right.
learning those skills about how important it is to have that communication and relationship with an instructing solicitor is not talked about often. So it was really helpful that you said that. So thank you.
That's all right.
What is an easy but very costly mistake in that can be made in preparing?
Um, an easy mistake to make in preparing a case.
Mhm.
I would say I would revert back to what I've said before, and it is not speaking to your solicitor.
Yeah.
Because if you don't speak to your solicitor beforehand and get an idea as to what the case is, what to expect of the client, you can very easily approach that conference, that first contact, badly, and it all go wrong from that point.
Okay, thank you very much. Okay, so now just experience and reflection in terms of yourself. So what was your first jury trial like?
Probably more serious than I should have been doing.
Really?
Yeah, I didn't think it at the time, but on reflection, probably was. It was involving a youth defendant and sexual allegations. It wouldn't actually now be at the Crown Court. I know we're going to come on to youth in a moment, but it would be being dealt with in the youth court. But back then, it was dealt with at the Crown Court. Um, I, I wouldn't necessarily, nothing went wrong. It's just that I probably, the only thing I probably did that you probably, this is one of the things you would do when more junior is you became too engaged with the defendant and his family, so to speak. So it was just probably needed to be a little bit more sort of, I don't mean it in a nasty sense, but a bit more standoffish.
Mhm.
I was far too sort of familiar with the family, and you tend to maybe lose your objectivity a little bit.
Absolutely. Especially when they're young offenders as well. You probably felt a
Yeah,
little
it
bit
was.
more sympathy.
Well, that was it. I think it was a young lad, and obviously I can't go into the details, but it was a young lad, and it was the complainant was young as well, and um,
You probably young as well. I know you're young still now. I'm not.
yeah, yeah, I was in my early 20s at that point. So, but it was, I remember it. I don't regret anything I actually did in the end, other than I probably would have approached that sort of client handling slightly different.
Yeah.
Um, but yeah, I think most people would look back and find some fault with what they did, and that was probably it.
Thank you very much. How would you avoid overcomplicating, whether it be case papers? I know you kind of touched on that skill a little bit by saying just when you're reading, go straight to the point. I think at bar school we get told relevance, 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 and sometimes it's hard to spot 'cause subjectivity, isn't it? You might think something's relevant and it may not be. So how do you really kind of draw a line to that?
Um, I think you've got to look at the issue. What's the issue in the case? Um, and there are things that can be relevant to an issue, but not particularly significantly relevant. And I think some people tend to get bogged down with the minutiae about, minor, minor points in a case, where you can then sometimes lose the major point, the key points in the case, because it's so littered, your cross-examination, for example, so littered with, you've obviously got to put your case. Um, but you can sometimes get a little bit bogged down in sort of minor points. Just get to the real issues in the case, because anything else is going to distract yourself and the jury and the judge.
Yeah.
Um, so it's try and think. I suppose from a civil side of things, in terms of drafting, which you draft defense statements in terms of and advices and things, is look at a paragraph and think, what words do I actually need in that paragraph?
Mm.
Do I need every single adjective in that sentence? Could it be trimmed down to a much shorter sentence? Can you say what was said in three sentences? Could you say it in one? So it's very much like that in cross-examination and in evidence in chief, is try and pare it down, get it down to the key important bits.
Okay. What are your personal strengths, would you say, as that you've got as an advocate? I have read the comments about you on Chambers website, but just for you to say, I know they say that you are there was a phrase that it was you're a straight to the point advocate.
Yeah, I like to get to the point.
Yeah.
I don't like to mess about. I don't want to. So for example, if I'm dealing with a sentence, I'm not the most sort of eloquent advocate in terms of, I mean, there's some really eloquent advocates that you hear. I'm probably not one of those. I'm probably like to get to my point and tell the judge, this is what I'm saying, this is where I'm going, these are my key points. Um, um, I recall being at the Court of Appeal once and then saying, the Court of Appeal, one of the judges said that's a bit of a Marmite approach, and well, either like it or you don't. Well, it is. You either agree with me or you don't on this point. There's nothing more I can say about it. So I like to be to the point, not being rude.
No.
I'm not rude. I like to be very polite. I'm a great believer in what is it, something called the 5 degrees of separation. You're five people away from knowing everybody on the planet. So if you're rude to anyone, they're going to then pass that on, and before you know it, everyone's going to think you're rude. So I would be polite to everybody. The moment you walk through that court, I don't mean just the courtroom, but the court building, be that security,
So,
be that the ushers, be nice, polite to everybody. Take time to be polite to other people. You are not better than anybody else just because of what you're doing.
yeah.
You are just doing something different. They may be far more intelligent than you, but they may not want to do your job. They may want to have a more chilled out life, doing a less stressful job where you don't take it home with you. Doesn't mean they're any better or any worse than you. It's just life choices in that sense. And sometimes people haven't had the opportunity that you might have had, or you don't know what's sort of going on in someone's background. So just be polite and kind to everybody else. Don't think you're better than anybody else because you're not. It doesn't make you any better doing the job you're doing. You're supposed to be doing your job to help people, be it victims or defendants. Just be kind and polite to everybody you encounter. I don't just mean at work, but in your life. I don't recall when I've last had an argument. I don't recall. In my daily life, I don't have problems with people because I like to think it's because I'm nice and polite with people. And that just makes my life a lot easier. And I'm sure it makes other people's lives a lot easier. And I'm sure that gets passed on. So my key strengths are, I think there are three to the point. I think I'm very organized. And I think I'm relatively polite and kind. And I hope that is what happens. And I certainly get that in feeling when I turn up at court. I know the security guards at court, friendly banter at that, love chatting to the ushers, have time for people.
Yeah, absolutely. And yeah, I think it's really nice what you've just said there to just remember that, you're not better than anybody else. That's really nice thinking.
You've just got different skills.
Yeah, absolutely. Because I think sometimes it can be quite overwhelming when you're, especially at, like, say, my stage, bar school, you can have some people who perhaps think they're a little bit better than you, or they've got an accent, or, a bit of a posher accent or anything like that. It's nice to hear that. Doesn't mean,
Yeah, just yeah, no one's better than anybody else in that sense.
no,
You've just got different skills and abilities.
absolutely. And
Someone might be good at cross-examination, someone might be good at closing speeches as barristers. You're still a barrister. It may be that as a barrister you're good at reading papers. Some people aren't good at reading papers, but they might be brilliant sort of at garden design.
yeah.
Courses for courses.
Yeah, absolutely. Um, What do you think? What do you think some of the biggest misconceptions that people have about how murder trials work, for example,
I
or
think
big
I
trials?
was Yeah, I think I was coming on to this, and I think the common misconception is I think that most people think that there's still a lot of sort of eyewitness evidence in that sense, and there's a lot of sort of I mean you get that, don't you, with sort of the dramas on telly where it's all about eyewitnesses and someone's been cheating or lying and there's some sort of backstabbing involved and it's all very complicated sort of cross-examination. Tend to be with murder cases and a lot more serious cases. It is that it's become very technical. And some murder trials that would have taken a week, because we were talking about how trials have become blurted with technology. Civilian witnesses are a fraction of that now. The actual civilians, and very often you've got someone saying, I saw X happen on this street. They'll not even be cross-examined. So there's very little sort of civilian input in most murder trials. It's very technical. There's obviously you've got pathology, etc., all the experts in respect of causation. You've got obviously your technical matters, so that what we call sequence of events charts. So that's where you've got, like you said in that drama, where they've extracted all the text messages, etc. You'll end up with a bundle, maybe about 50 or so pages with lines of data. So it can be quite dry. That's the sort of because it's become very technical, and that's even more so when you've got multiple defendants, where you've got more secondary parties who've now been caught and snared by messages between people. So in the past, it would have been the shooter because
Yeah.
she was seen doing something. Now you've got who took the shooter, you've got the person who sort of nicked the car or the person who burned the car out, you've got then assisting an offender or perverting the course of justice when people are disposing of stuff. So it's become much bigger and more technical and less sort of dramatic. They're
Mm,
not very dramatic murder trials. They're
yeah.
very dry.
When I was working as a paralegal in my previous position, my director had taken on a criminal appeals case and it was a murder case, and he let me have a look through the papers and he set me a task to go through the cell site evidence and to do a summary of it. And
Yeah.
exactly what you've just said there, I didn't know it was called a schedule of
Sequence of events chart, yeah.
sequence events, sorry, yeah. And I couldn't believe how many pages there were of text
Yeah, it's just line of data, line of data, line
and
of data.
colours everywhere, and it was just like,
Yeah, yeah.
wow. And to unpick that,
Yeah,
um,
well, you end up, yeah, exactly. You end up actually with, in effect, the prosecution barrister adducing, because it's all obviously got to be agreed. There may be circumstances, bit points, and matter of interpretation, and you'd flag that with the jury to say this is suggested by this, but there's an issue on this particular point. But the vast bulk of that document, the SOE, is going to be agreed. So it's lead evidence. And so you can end up with a data analyst being put there, uh, you know, um, in the witness box, giving evidence about that. But in reality, it's prosecution counsel almost being the witness, leading the witness through it.
yeah,
It's just effectively going through that detail. You've got to bear in mind because you've got to have a bedding in period with the juries while they get familiar with it. Because whilst you might be familiar with this, they might just think, gee,
that was me.
yeah, what on earth's this? Yeah, exactly. You recall seeing it thinking, how do I get all these colours? So you've
Yeah,
really got to have bottomed that out as prosecuting counsel in respect of that case, because that is your case. Most conspiracies, the conspiracies I've prosecuted, are all based on these sequence of events charts. Most drugs conspiracies are maybe 2 to 3 weeks of just going through this material and presenting that to the jury, which is all uncontested. And then it's sort of what we call confess and avoid. It's then the defendants will then say, well, yeah, I did all this, but this is what I was doing. I was selling cigarettes, not class A drugs, or that sort of thing.
and what is your opinion, if you can give me one? I'm not sure if it might be red tape, but if you can give me one on the Encro phones and how they're getting used for conspiracies, do you see a lot of data getting pulled off of them as well when they can
Well,
be pulled off?
yeah, well, there's been obviously the famous EncroChat thing, which the French police, and there's been a great deal of those. There are obviously phones out there that obviously offer a different service that are being used. As to what they are, they've not surfaced in that stage. But you've got obviously there's been a great deal that then flowed from the French investigation involving drugs conspiracies. And there's been a number of cases. I've been involved in some of those cases from the defence side of things. And what obviously happened in respect to those cases in terms of um, in general is that because they thought it was encrypted, rather than that being rather guarded and sort of coded or very limited information, they were just chatting freely.
Yeah, of course. Of
So
course.
it was in a sense the material made it far easier to prosecute
Kind of
because
like,
it was unguarded. They didn't think that it would be cracked, but it was obviously.
mm,
I suspect that there are um, comparable systems, if not more complex systems, out there being used by organized crime groups. Um, I'm sure that the security services will be dealing with that, but that's not in my gift to know at this stage.
yeah, of course. And I guess that's like part and parcel of technology, isn't it, as well? The more technology more we advance in technology, the worse it's going to get in that sense. Well, the more
Yeah,
intelligent it's going to get in that sense for sure.
yeah, yeah.
Okay, well, thank you ever so much for that. So, in terms of now young and vulnerable witnesses, and how you deal with them, how do you try and ensure that your witness, say, for example, it's in a serious sexual offence case or a GBH, something like that, how would you make sure they're relaxed in terms of when they're coming to give their evidence?
It's for starters, it's got to be obviously work out what the issues are before you actually meet.
Mhm.
And so there may be, if it's a defense or prosecution, you've spoke to your solicitor again. If you're defending, if you're prosecuting the officer in the case, they'll have been engaged with the complainant over a longer period of time than you will have done. So you'll have got some understanding about that. It could be that there's a case where it's involved in an intermediary. So there might be an intermediary report to deal with communication issues. So as long as you familiarize yourself with that sort of level, in terms of sort of Section 28 cases where it's a pre-recorded cross-examination, if I'm defending, I tend to obviously will have read the case papers, read the report. The reports are uploaded onto the digital case system. I'll draft my questions alongside doing my defence statement. So I've got the fresh instructions. It's fresh in my head. I know what the defence instructions are. I'll draft those questions. I'll email them and liaise directly with the intermediary. So it's all sort of done. So there's a great deal of prep you can do before you actually go into that room and meet either the defendant or the complainant. So just, know where, what sort of capacity they have, what sort of abilities they have, what issues they might have about things. Um, and because you, again, if you've got a victim who doesn't want to refer to the defendant by a certain name, you can do a great deal of damage by sitting down and saying, right, you're going to be asked questions by your dad. And
Yeah.
if you use the word dad and they've to compartmentalize things to help them sort of recover, they ain't using the word dad for
No.
whatever reason. And you've gone in there and used that word, you can create a great deal of damage. So it's, you speak to the officer, just say, look, how am I? Because they'll know being well. How, or you intermediary, or you can do it in a more sensitive ways. Look, I'm defendant, how would you like me to refer to him? So those sort of should be, have you prep yourself, be ready, um, make time. So when you're prosecuting, you've got what we call the speaking to witnesses at court, SWAC. That you spend time, that you're polite, you sit down, you take your wig off, you're not standing over them.
Yeah, of course.
Um, if it's a child, obviously make sure that you probably just go with this jacket and tie on, because they'll see people wandering in with wigs and gowns and be completely freaked by the whole thing. So it's just to get to know a little bit about and adapt again. It's that word adaptability again, flexibility. Be adaptable to that person, to their specific needs, because it's not a one case fits all sort of situation again.
Yeah.
It's know what might be the pinch points in respect to this witness, make sure that you know or if they've got any sort of requirements for special measures, and you've obviously discussed special measures with them, and take time to discuss things with them. Don't use complicated language, obviously. Just use common ordinary language. Again, I suppose this goes back to to trials in a sense. I think that it's very great and lovely to hear really sort of eloquent barristers using wonderful words that I've no idea about. You've got to think about your audience. Is the jury um, going to know what you're talking about if you're going to be using fancy language, or they're just going to think you're, you know, a prat or whatever for using that and just think, oh, he thinks he's better than us or she thinks they're better. Just I don't think people have that expectations these days that you're gonna. It's not like the 1940s, 50s sort of thing. We don't have that sort of class situation now anymore. So just be normal, be yourself, and try and be friendly and as open as you can, and have some regard to the person you're going to see beforehand. Because as I say, you can really rapidly undo it if you start using or say things that upset them.
It's just like having, by the sounds of it, people skills, really, isn't it, as well? Then just being
Yeah,
empathetic. If somebody was to tell you traumatic story, you're not going to start to use lots of different words and make them feel uncomfortable. You're just going to listen to them, aren't you, really, and
yeah,
try and
quite.
not be there for them. I know it's crossing the line,
Yeah.
maybe. Yeah. Um, I know that now there is a lot of like training around vulnerable witnesses and young witnesses. And do you think it can be quite a hard skill to master to for some people to come back down to that level, like you've just said
Yeah, I
there?
think very few do actually master it. I
Hmm.
think there's the and some people, don't want to do cases like that. It's not everybody at the bar is capable of doing that necessarily. I think many of us who deal with cases like that often will recall instances in court where your opponent, you think, well, I'm not sure I would have done it that way, So um, yeah, it's a hard skill to master that.
I think
Um,
some people
I,
have like personality of Rottweilers as well, don't they? So it might just be in their nature,
yeah,
kind
I'm not naturally aggressive person. I don't think personally it achieves much. I think if you're going to be aggressive towards a vulnerable witness who's upset, giving evidence, you're going to have a jury probably sat looking at you thinking all manner of things about you. You know, it's not a fair contest in that sense. I mean, there is an occasion if you're prosecuting and it's a sort of a violent offence, you know, you can be a bit tough. Or you're cross-examining a drug dealer about that, you can perhaps have a bit of irony in your questioning. But I think if you're anywhere near a case involving children or victims of sexual abuse, if you start being aggressive, you're going to blow your credibility, you're going to upset the judge, and you're going to upset the defendant. Sorry, the jury. You, you're not doing a service to your client. I've no doubt a lot of clients want you to shout at the complainant and say that you're a liar, but they don't. Whilst you're bound by their instructions, you're not bound by how you present your case. That's your professional judgment. And I don't think if you're going to be shouting at victims, vulnerable victims, you're going to be doing anybody a favour.
Mhm.
And you just tell your defendant. Sometimes if you've got a defendant who thinks they're going to do that, just tell them, I'm not going to be shouting at this witness. These are the points, and explain to them why you're going to do it.
Yeah.
Be open to the defendant. Say, look, if I go in there, start shouting at this person, all they're going to do is cry. Is that going to help your case? No, it's not.
Yeah. Yeah, absolutely. Just about reading the room, really, isn't it?
Yeah, again, it's flexibility. Some
Yeah.
cases you can be aggressive. Do not be aggressive though in the majority of sexual vulnerable cases. It's not going to help
No.
anybody, and the judge will hate you for it.
Yeah. Yeah. Um, well, I guess that kind of answers the next question, which was how can the age and maturity of a young defendant influence proceedings? Of course, that same rule will apply, won't it? Learning how to speak to them, checking
Yeah.
if there's other special measures
Yeah, they're
needed.
quite limited, the defendants now, youth defendants in cases, unless obviously they've committed indictable offence linked with adults or it's a murder case. The vast majority actually now stay in the youth court. Most youth rapes are dealt with at the youth court these days. And so it's not something that comes up as much in the Crown Court these days because, as I say, the youth court's taken a greater share of that work. But if you are, just adapt your approach. Be mindful of who you're dealing with.
Yeah. And is it right that in the youth courts now you're not roped up and it's a little bit more
I
relaxed?
haven't been in a youth court for a long time, but
Oh,
yeah, I
sorry.
know people. That's all right. Some people do, they can do it. There's the grade 3, grade 4 barristers do a feature in rape cases in the youth court. I haven't personally dealt with one myself for a long time, but yeah, it's there's no wigs and gowns or anything like that in the youth court. It's all very much more relaxed approach.
Yeah. Okay, thank you very much. So when, say, for example, you are prosecuting a case and the complainant in the case is a young witness, do you like to, but say the defendant's an adult, would that be held in the Crown Court? Yeah.
If there's what, sorry?
So if it's an adult defendant, but the
Yeah,
complainant is a child, then it would still
yeah,
be held in the
yeah.
Crown. Yeah, of course.
That's
Sorry.
Crown Court, yeah. It's only youth defendants if it's at the youth court.
Yeah.
And yeah, and that's quite frequent. That's
Yeah.
particularly in RASO cases, sexual cases, that is quite frequent. It's on a regular basis when I be cross-examining. I think the youngest one I've had in a trial recently was 4, the complainant.
What
Um,
would you say the first step in that is then going down? What would they even be brought to court? Probably not. Is it usually via video link now?
the process is with all RASO cases that they would be dealt with by way in chief in an AB interview. So they'll be questioned by the police at an early stage. That's then obviously transcribed and copied, and you would edit out bits that are inadmissible because of the a police officer is in a difficult position because at that point they'll have got a limited amount of information and they'll be trying to elicit the answers, but without leading, so that they can't be more to the point like you could be because you've got a statement to work from. They haven't. They might have an early contact book to work from, or some notes made when there's been the initial contact. So it's more of a voyage of discovery, and sometimes it can be very hard for the police, I think, to sometimes moderator witnessing as to how much they say and where they go because they don't know where they're going. So you might end up a witness talking about a lot
Mm.
that is irrelevant. And I think sometimes barristers and judges think, well, the police don't know how to control the witnesses, and it's all, it should have been done in 45 minutes and it's 90 minutes, and this is far too long. I think you sort of overlook the difficulty that police are in at that stage. I think there is a difficult position with the police officer. They don't know necessarily the full account. They haven't got the case papers to read at that case, so it's a very much of a voyage of discovery. And so there can be quite a lot where there's material that's just unnecessary. And so you've obviously got to trim that down. So that's all pre-recorded. So you've got the evidence in chief, and now certainly with any witness under 18 in terms of sexual allegation and most allegations, there'll be pre-recorded cross-examination. Um, just a point of warning though with pre-recorded cross-examination is it certainly with adult witnesses, there was a stage where everybody, because there was a big backlog, everybody wants to be cross-examined sooner rather than later. I get that. I understand that. The system, ideally, you want trials done within 6 months when things are fresh in people's minds. But sometimes with Section 28, it is a bit of a clunky system in terms of the fact that it's more stage managed and can look like that. And you've not got the opportunity of sometimes you've got someone giving evidence on a screen rather than in person. And I think sometimes that can impact on a jury. So I think certainly for children, I understand it, not a problem. Section 28, get that done. Um, Adults, I would try and I'd like to think that the police now don't just say as a matter of course, and you could potentially be cross-examined beforehand because you're going to potentially lose that. It's far more impactful. I know not everybody can do that, and special measures, there really are general measures these days. They're not particularly special. You can count them all the time. But I think in terms of um, dealing with the case and how you want to do that, obviously it's got to fit to, you might get a witness who's just frightened of coming into court because of being in front of people. Perfect. If that's the case, they're not going to give evidence unless they give evidence via a live link. You might have a witness who's quite happy to be in court but not want to see the defendant. Perfect. You've got screens. And so again, flexibility. Don't just say treat everybody the same. Look at that person, look at that individual, and speak through them. Speak to them when you speak to them at court. These are the options. These are what the issues are. Because quite frankly, I do think it is more. Some of the impact is lost from witness evidence when it's all pre-recorded. It can become a little sterile and you just miss that. You're not getting those emotional cues you'll get with a jury and the witness being in front of the jury.
Yeah, I was just about to say, do you think it can sometimes disengage the jury a little bit if they're just watching it on a screen?
I wouldn't say always. I wouldn't say it causes disengagement. I think a jury would be engaged, but there's that sort of subliminal sort of impact that having someone in front of you telling you something graphic and devastating in person. You can't quantify it. I'm not saying that that means that they're going to ignore or not listen because it's on a screen. But I don't know how you would ever quantify it. But there is just that, that human electricity that the between you seeing someone telling you in front of you, it is more impactful. It's
Yeah.
hard to explain why it is, but it just is. I'm not saying it devalues the other, but I think it probably elevates the in person. So, yeah, special measures are there for children. Very often means that children themselves don't give evidence anywhere near the trial date. But when moving on with this question as to adults, don't try and pigeonhole things into just all links and Section 28. If a witness is willing to come into court, because you couldn't lose some of the impact of your case.
Yeah,
I'm
absolutely.
not saying you then force a witness and say, this is how I want you to do it. It's entirely their decision. But as long as you give them the knowledge, empower them with that knowledge to make that decision as to what they then want to do and what the pros and cons are.
Thank you so much. Um, Also, do you think there could be any more support mechanisms within the criminal justice system for young people involved in proceedings?
In terms of defendants, probably not, because you've got so generally always in the youth court, you'll have got the solicitor or counsel if it's a trial, if it's a RASO trial, for example, and you've got the youth offending service who are always there, they're always good. I mean, when you get a youth coming up to the Crown Court, the youth service are always there. There'll have been engagement. There's a lot more engagement now than there ever was. So in terms of youth defendants, probably not, and they'll moderate the proceedings to accommodate a youth. In terms of youth witnesses, I think sometimes there can be too much of a lag in the investigatory stage. So you know, what I mean by that is that I've been in situations with cases where cases listed for PTPH, you list in a section 28 very quickly because they're a youth. So within, I don't know, 4 weeks, 6 weeks, or depending on whether your timetable is, but in a very short space of time, yet the investigation could have been 2 years in the making. And so I think in terms of, and again, I'm not, it's not a criticism of the police in this sense because they've got a very complex job, and the CPS when they're reviewing lawyers, they've got a huge case log to deal with limited resources. But it ought to be, in my view, that there's more um, resources given to that investigatory stage to assist in young, certainly young allegations, because child's mind it alters as they grow older. The perception will change and memory fades very quickly with children. And it's no good having a case come to court where the complainant was 4 at the time and they're getting cross-examined when they were 6.
Mm. Yeah, of course, and that's the backlog of the criminal justice system at the moment, isn't it, where things are taking a long time to go on to.
Yeah, the whole sort of system is sort of, and there's the knock-on effect of the adult case. The whole system is sort of um, snared up with just the backlog, and that impacts on the courts. It impacts then on CPS, and then it impacts on the police, and therefore that's why you end up with that time lag. And technology comes into that again, because if you've got phone downloads involved in cases where there might be messages that are relevant, and you've got social service records if it's for kids as well,
Mm.
there needs to be a real sort of um, all arms sort of approach to, social services need to be engaged quickly, the police need to be engaged quickly with children to ensure that as soon as that child makes a complaint, it is reviewed and then, if charged, dealt with very quickly. Because the memory of a child is very much susceptible to time delay, than more so than an adult.
Mhm. Off the back of that, is there anything that you would, if you could pick one area to reform of the criminal justice system at the moment, what would you pick? And also an area of law as well.
More resources in terms of um, pre-trial, in terms of investigation,
Hmm.
and so more resources for like digital sort of the extraction of digital material. They're often very overworked. Again, they're the sort of forgotten people of the justice system, where they've sort of been told or demanded for by the courts to sort of do ABE edits or Section 28 edits or obtaining downloads, etc. More is, and it could often be it's just like 1 or 2 people in the police, civilian employees of the police who are dealing with that, and they're just swamped with that level of work. That causes a backlog. So it's, if you want to really improve sort of the way that people understand and feel the criminal justice system and how it impacts on their daily lives as a complainant and a defendant, because it's no good a defendant waiting for years and years and years with something hanging over them,
Mm.
when it then may not be prosecuted. You could have spent 3 years suspended from work, just, and then it's not prosecuted.
Mm.
So, yeah, the Crown Court's got its problems, but I don't dispute that. But in term and the bar, there aren't enough barristers, etc., or judges and courts available. But if you want to really know whether that it starts, you've got to start it early and start to really be able to target it towards early sort of charging decisions. Um,
So pre-trial, yeah, and the investigation. I've not heard
yeah.
anybody say that in any of my episodes. You are the first. You take the crown for that. Um, okay, so thank you so much for that as well. And in terms of multi-handed defendant trials, then, so what would you say the strategy is? Say, for example, you were defending it. Would you speak to the other defence barristers in the case? And would that change if it was going to be a cutthroat defence? So if it was going to be where they're all blaming each other, would you avoid chatting
Well,
to
you
counsel or not?
Yeah, well, obviously, what you information you're given is privilege, but yeah, obviously you can work out where people are going in the case and get as much information as you can as a whole, so that you just have an idea and expectation where the case is going to go. You will have, generally speaking, have an idea. The defense statements that you prepare though aren't ordinarily disclosable, so it can very often at the start of a trial, no one actually knows what the defenses are. The court can order or you can agree to cross disclosure of defense statements. But there can be many situations where people just don't want to do that. And so you know, and you're stuck with that situation. It's very difficult to manage, and that can often be the difficulty in a murder case. You've got all the Crown's case can be very dry, where you're presenting all the sort of dry material from a sequence of events chart and playing CCTV sort of compilations, and you've called a pathologist and you've called another scientist to do with firearms, for example. So it's all been very dry. The drama starts when the defense start giving their evidence because no one will know what it is until the point that they do it, because invariably they will have gone no comment in an interview.
Yeah, of
So,
course.
it really is a voyage of discovery, and it's sort of seat of your pants sort of stuff is
Yeah,
when co-accused start giving evidence.
I can imagine.
But you'll have an idea for that, generally speaking. But obviously, you can't say anything that goes beyond your privilege.
Of course. But do you think that's probably one of the quite difficult aspects of prosecuting or defending one of those trials then?
Yeah, defending them can be very difficult. The most difficult, it tends to be, I think I've used this phrase before, confess and avoid. In most of the time, the Crown's evidence isn't challenged.
Yeah.
It's very rarely challenged. So the easy part for the defense sometimes, actually the prosecution case, where it gets a little spicy, is where the co-accused are giving evidence. Um,
They all start
and
pressing on each other.
yeah, and there is no sort of omerta amongst criminals when it comes to most murder trials.
Yeah, I can imagine.
It very much is that everyone wants to be at the back of the sort of the incident, so
Yeah,
they're all vying to be that person running in late on the CCTV.
yeah. Um, okay, well, yeah, you've just kind of answered my next question, which was going to be the most difficult aspects of it. But actually, what, in your experience, what would you say the most difficult multi-handed defendant trial was that you either prosecuted or defended? I know you can't go into detail about it, but maybe just what was difficult about it.
Um,
Pick one.
yeah, I would say there was a murder case involving two youths.
Hmm.
That was very difficult. They were very young. It had happened in uh, circumstances where certainly one of the youths had been at a funeral that day for someone very close. I don't want to give any more information than that, obviously, because it's some sort of jigsaw sort of ID sort of thing.
Yeah, of course.
And it was very difficult because it was quite emotive. Um, a case where they had to be great. It was a very slow process as well because they both had learning difficulties, if I remember, and that we could only sit for a short period of time in each case. It just took quite a long time to deal with. It was just a quite a sad case, really, because it was just sad all around because the victim was a vulnerable person as well.
Mm, yeah, wow, thank you for telling me that as well. And actually interesting, I did my degree in Essex in the University of Essex, and all of my minis and things like that were based in London. And that was one of the reasons why I was really excited to come home to well, Middlesbrough is my home, but just come back to the north was because
Mm.
all of the cases that I was seeing in London were all um multi-handed defendant murder cases, attempted murder of people
Yeah,
young as 13, 14, killing one another because of gang affiliations and things like that. And it was so sad. It was really sad.
yeah. There's a lot of knife crime, sadly, at the moment, and that
Yeah,
not just in London, but it's
of
particularly
course.
prevalent in London in terms of the cases that they deal with, and it's very sad to see young people in that situation, often hurting other young vulnerable people.
Even one of the cases that I saw was where the defendant was just carrying a knife for his own protection. So he said,
Mm,
um, which I think I believed him, but it's not a case for me to believe because I wasn't on the jury. But he said it was because he lived in Enfield and it was a really really rough area, and he was terrified that one day he might get killed, for being a
mm.
black young boy. That's really sad as well to think that that's where we are in society now. People are carrying weapons to protect themselves.
Yeah, and there's been a sort of growth in sort of firearms, not necessarily the firearms that, I mean, I went sort of 15 years with hardly any firearms sort of practice in the Northeast. There's a lot of it now with a lot of it sort of homemade firearms, either printed firearms or reconditioned firearms or what we call slam guns, where people have got sort of pieces of metal sort of scaffolding pipes and created sort of homemade shotguns where, I mean, there's dangerous to the people using them, where they'll just put slam one piece into the other and, you've got your homemade firearm. There's a lot of that now, and there seems to be this sort of general disregard of other people. It's just, but it tends to be, sadly, young, deprived, vulnerable people who are involved in this, who end up with involved in drugs and gang crime because there aren't the alternatives available to them, or for whatever issues that they've got going on in their lives. It's all very sad.
Yeah, and that's quite a difficult rabbit hole to go down, isn't it? Because that would involve like different services in the community intervening, and how do you look at
Yeah,
that
I
short?
suppose it's I'm probably getting a bit political here in that sense. I suppose
Yeah,
it's
sorry, yeah.
where you get, I suppose it's the problem where you've got, it's where it, input and result. Um, it's great to see that the police are, in cases like that, able to input and the courts the resources to prosecute these children and young adults. Yet, probably a fraction of that spent on a youth club might have prevented three people from going to court. But how do you quantify that?
Yeah, how do you even
How do you do the cost analysis to say, well, if I invest 50 grand on this youth club, it's going to prevent X murder? It's not. And so you can't quantify that. And therefore, I suppose from a side of politics, in the sense that if you're if you're a politician, you've got an electoral cycle of about 4 to 5 years. You want to put X amount of money in to see return in 3 years. Otherwise, you're not going to be there potentially for year six. And the problem is that because it's cyclical in that sense, you get systemic sort of long-term non-funding in things that would divert people. The same applies to health. The same applies to the courts. Um, it's not. It's not. It's sort of dealing things with after the horse has bolted, sort of thing.
yeah,
And it can be much more expensive locking people up for 15 years of their life than investing 50 grand in a youth club. But
mm,
everyone wants to, in the newspapers, want to see someone locked up for murdering somebody.
yeah,
Do you see the clamour for everyone saying, why is this youth club closing down? Why
yeah.
is this scout group or whatever closing down? It's sadly the way that people sort of do the cost benefit analysis.
I don't think smartphones help in that sense either, because children now just all go on the iPads, don't really like to play out anymore.
Yeah,
I know my little
that's probably
brother's
right.
terrible.
It's, it stops people from engaging with one another and meeting one another and having, I suppose it's like, I suppose when people drive, it's all very easy. I don't get road rage. I don't, just be chilled out. People make mistakes at the end of the day. If someone's pulled in front of you, all right, as long as you're not hitting, it's great, in that sense. Um, but people see a car and see an object and are happy to be aggressive and shouting at that car. Had they bumped their trolleys at the supermarket, they probably wouldn't, because you
Exactly.
see an individual. And I suppose social media is that. It's very easy to say something utterly horrible and despicable online, when in reality you knew that person, you could see that person in front of you, you wouldn't do it.
It was almost similar to that case that we were talking about at the start that was on 24 hours in police custody. The sometimes young people are like self-radicalizing themselves, and they haven't
Mm.
really got a group of people around them because they're not interacting to kind of have that moral compass. Say for
Yeah,
example, I say something, my friend might say, Ellie, you can't get upset over that. And I'll be like, oh yeah, actually I'm really drama queen, but I've
yeah,
got
yeah.
that
You need
cue.
moderation. You need a mix. You need a mix of people, and this is
Yeah.
why I suppose you've got, that's that phrase of echo chamber. You've got people are sort of self-radicalizing in to the right, to the left, in all manner of ways, because you're. It's very easy now to go online and see people who might have similar mindsets to yourself, and then you're going to then potentially gravitate towards them. Whereas before social media, you could walk into your local town, there might be one person who might hold those similar views, you might not ever see them. So you amongst people of different thoughts, of different sort of experiences, where people aren't having that exposure to different people, different views, and therefore there is a lack of tolerance when it comes to different views and different people.
Yeah.
And it's very sad because you end up in that echo chamber situation where people become entrenched and hold certain views and, as you say, self-radicalize.
Yeah, thank you ever so much. So I just have three more questions and then I will release you of your duties. Thank
All
you so
right, no
much
problem.
for sticking
I
with
can
me.
see the emails pinging in as we speak,
I
but
know I'm really sorry. And obviously I have a lecture in half an hour as well, but you've made my
don't worry, it's absolutely fine.
day
I've enjoyed it.
much more exciting than what it would have been if I was sat in the library. So my first question is what has been your proudest moment in your career?
Um, Proudest moment in my career. Um, I think my pupils. I
I was
see my
just
pupils do
That's
well.
so strange you've said that because I'll ask you this question in a second. But my second question is, that's really lovely to hear actually. I've got a lot of Park Square barristers on my LinkedIn, so when I do post this, I'll definitely clip that part and they'll all be obsessed and over the moon for the year, I'm sure.
I was
Um,
actually just become a tenant today, in actual fact.
oh, that's amazing. Oh wow, congratulations to him or is it her or he?
Uh,
Her. Um, also, the second question is, what is one thing you still want to take off your list for your career that you haven't yet done?
um, I've not really minded necessarily to the judiciary sort of level. I'm quite comfortable and happy in doing what I'm doing in that sense. But there's a certain application that you might reach at certain stages in your career that you might want to do, and that's probably
Yeah, okay. Oh yeah, I'm sure you'll
it.
definitely get that straight away.
I'd like to give it a go.
Yeah, well, I'll do another podcast with you when you are at that when you are then as well, and I can say, what's the next thing that you want to do.
But I
Um,
love it. I love the job. I mean, I was told I don't come from particularly wealthy background or anything like that. Went to a comprehensive school. Probably could have done better at my A levels if I hadn't discovered drinking so early on. Um, so and I was told repeatedly why you want to do this. You don't know anyone in the law. It's a dying profession. That was what that was when I was 17, 18. That's quite sadly some time ago. Um, and I was told it's a dead end job, don't do it. And I'm a great believer in thinking, look, things happen for a reason. Um, Sometimes good, sometimes bad. But if you've got the ability to choose to do something, that's a rare occasion because a lot of the time in life, things happen to you and they're out of your control. Whether you get pupillage or not is out of your control to a large extent. Sometimes can be chance. You can improve your chances in respect to that, of course. But if you make a sort of an individual decision not to do something through fear or from what someone else has told you, you actually have control over that decision, and that's your decision. And I'm a great believer in thinking that, look, if you've got the choice to and you want to do something, try. Because there's a long way back in your life where you might think, I wish I'd tried. And
yeah,
if you've tried and you've not got there, you'll have picked up some skills that might have helped you in something else, and got something else. And my view is to anybody who wants to a career at the bar, and it's great that it's a lot more diverse these days, and hopefully getting more diverse, is that it is a fantastic profession. You have a great deal of control over your career, and it is so rewarding. And I would wish that anybody who's think about it at least tries. Yeah, there can be financial impact upon you in respect to that. I wish there wasn't. That's out of my control. But if you want to do it, give it a go. You might, you might sort of regret it if you don't.
yeah, absolutely. Thank you so much. I'm sure a lot of people benefit from hearing that as well. Um, and the last question going to ask you was, what are you most proud of your junior barristers and your pupils for in Park Square?
I think the attitude that they've got is fabulous. They're just the attitude sometimes among some more senior professions is quite grumpy and quite sort of downbeat, but it's just refreshing to see young people engaged, wanting to, have a go at this career and just seeing in them a great sort of positive attitude, and it really is great to see them and watch their careers develop. To watch them go from struggling with a magistrate's trial to then just, in a few years' time dealing with a trial, and you can think, well, I've had a part in that. We've helped that person do that, and so it's great to see that. Just as great to see that progress.
Well, Paul, I can't thank you enough for joining me this afternoon. You have definitely made the episode very fun, and I've taken away so many tips as well that I can use, especially at bar school at the moment, to keep him relevant and getting straight to the point. So thank you so much, and I know how busy you are as well, so I really, really appreciate
Yeah,
it.
no problem. It's been a pleasure. I've really enjoyed it. It's
Oh,
great. It's great to see someone so keen in respect to this. More than happy if you ever got any questions, just to email me in that sense.
yeah,
And, uh,
absolutely.
and
Thank
just remember, be nice to people.
I will. I think sometimes I'm probably a little bit too nice to people, but no, you
Yeah, just,
can never
just be
not be
nice.
too nice anyway. You can't.
It rubs off and makes your life nice as well.
Exactly, that's very true. Oh, perfect. So, am I okay to circulate this recording around as well?
Absolutely. Yeah,
Thank you. I'll stop the
absolutely.
recording now. Thank you so much.